Hello aspirants, welcome to Professor Academy. In this video, we will be discussing National Green Tribunal 2010. As you all know, National Green Tribunal 2010 is an important legislation under environmental law in paper 2. So let's discuss the legislation. Okay, so if we take National Green Tribunal 2010, we have 5 chapters, 3 schedules, and it came into force on 18th October 2010. So, in this slide, the 3 schedules and the date in which it came into force is very, very important. It has been asked many times in our examination. So, NGT na large chapters irukku, 3 schedule irukku. When it came into force, in the question வந்துட்டு பல வாட்டி நம்ம எக்ஸாம்ல கேட்டிருக்காங்க. It is none other than 18th October 2010. In the National Green Tribunal, it's a specialized tribunal that deals with environmental law matters. So environmental matters deal பண்றதுக்காகவே ஒரு தனி tribunal வந்து உருவாக்கியிருக்காங்க. So எக்ஸ்க்ளூசிவா ஸ்பீடியா ஒரு environmental decision கொடுக்கறதுக்காக இது establish பண்ணிருக்காங்க. If you see the place of sitting, we have 5 places of sitting for this particular tribunal. So the principal places Delhi. Next we have Kolkata, Pune, Bhopal and Chennai. So மொத்தமா 5 places இருக்கு அந்த tribunal. First principal place வந்து டெல்லியில இருக்கு, நியூ டெல்லியில. நெக்ஸ்ட் பிளேசஸ்ல பாத்தீங்கன்னா போபால், கொல்கட்டா, பூனே அண்ட் சென்னை. இதுல எல்லாம் இருக்கு. சரிங்களா? Next, so preamble. Preamble of any legislation is very, very important. And if you take in our examination orientation, preamble வந்து நிறைய கொஸ்டின்ஸ் கேட்டிருக்காங்க. ஸோ preamble பார்க்கறது ரொம்ப ரொம்ப இம்பார்ட்டன்ட். இந்த preamble நான் வந்துட்டு நான் பிரேக் டவுன் பண்ணி கொடுத்துருக்கேன். ஸோ இதுல இருந்தும் எக்ஸாம்ல கொஸ்டின்ஸ் கேட்டிருக்காங்க. ஸோ கைண்ட்லி give focus for preamble. So in preamble, it has stated that the purpose of NGT, the establishment of NGT for the effective and expeditious disposal of cases relating to environment protection, conservation of forest and other natural resources, including enforcement of any legal right relating to the environment and giving relief and compensation. So basic establishment of the NGT, the main purpose for effective and speedy disposal of cases that is relating to environment and environmental protection, conservation of forest and natural resources. So cases சீக்கிரமா வந்து dispose பண்றது மட்டும் இவனோட purpose கிடையாது. To also give relief and compensation for damages caused. இதுக்காக தான் மெயினா வந்து இந்த NGT எஸ்டாப்ளிஷ் பண்ணியிருக்காங்க. அதுக்கப்புறம் இங்க பாத்தீங்கன்னா இந்த 2 இன்டர்நேஷனல் கன்வென்ஷன்ஸ் மென்ஷன் பண்ணிருக்காங்க in our preamble. ஓகேங்களா? ஸோ வந்து பாத்தீங்க அப்படின்னா the United Nations Conference on Human Environment, which was held in Stockholm in June 1972, which India is a party to it, and we have participated and calling the states to take appropriate steps for protection and improvement of human environment. So 1972, you all know, India participated in this Stockholm conference. So adala வந்து என்ன சொல்லிருக்காங்க அப்படின்னா வந்துட்டு it called the state party to take appropriate steps to protect and improve human environment. Next, we have also participated in United Nations Conference on Environment and Development, which was held at Rio de Janeiro, Brazil in the year 1992 June, which to provide effective access to judicial and administrative proceeding. So, இப்போ நம்ம environment வந்து protect பண்றதுக்கு வந்து ஜுடிஷியரியாகவும் அட்மினிஸ்ட்ரேட்டிவ் ப்ரொசீடிங்காகவும் லைக் மக்களுக்கு வந்து ரெமெடி கொடுக்கறதுக்காக டெவலப் பண்ண சொல்றதுதான் வந்து இந்த ரியோ டி ஜெனரியோட கான்ஃபரன்ஸ். ஓகேங்களா? ஸோ ஹியர் இன்சிஸ்டிங் the member country to take administrative steps, judicial steps by framing laws regarding protection of environment so people can get compensation if there's any case of pollution in the environment. ஓகேங்களா? ஸோ அதுக்காக இந்த பர்டிகுலர் கன்வென்ஷன் கொண்டு வந்திருக்காங்க. அப்பார்ட் ஃப்ரம் திஸ், in the preamble, they have mentioned Article 21 of our Constitution. So Article 21, you all know, right to life and personal liberty. So time and again, in many cases, they have held that right to free and healthy, right to clean and healthy environment is part of Article 21. So even that has been mentioned here. And the preamble further stated that, see, this particular institution is a multidisciplinary, multidisciplinary issues will be taken up. So இதுல தான் இந்த preamble சொல்லியிருக்காங்க. So in toto என்னென்ன சொல்லியிருக்காங்க அப்படின்னா effective and expeditious disposal of cases and providing relief and compensation for the victims in case of any environment pollution and damage. And thirdly, they would have mentioned about the two important environmental international conventions, like the UN Conference on Human Environment, which was held at Stockholm. Next is United Nations Conference on Environment and Development, held at Rio de Janeiro in June 1992. And they also mentioned about Article 21 of our Constitution of India. Okay, so next, now we're going to see about the important definition, that is the word environment. It is given under section 2C. This is very, very important, which they have asked so many times in examination. So definition 2C la வந்து பாத்தீங்கன்னா environment word define பண்ணிருக்காங்க. So previously கூட Environmental Protection Act la environment define பண்ணிருப்பாங்க. They have the same definition. So இங்க NGT la 2C la கொடுத்திருக்காங்க. So don't forget, it includes water, air, land, and interrelationship which exist among and between water, air, and land and human beings, other living creatures, plant, microorganism, and property. So, இங்க என்ன சொல்றாங்கன்னா, it's very simple. Relationship between air, water, and land, the interrelationship between human beings, other living creatures, plants, microorganism, and property. Okay, so kindly remember this definition. Our interrelationship between the biotic and abiotic தான் சொல்லியிருக்காங்க. That is abiotic like air, water, and the land, with the biotic like human beings and other living creatures like animals, plants, and microorganism and property. Here, in the recent examination, they have asked about the definition of environment, and here they have given a blank. So the definition கொடுத்துட்டு கடைசில இங்க blank கொடுத்துட்டு fill the blank அப்படின்னு கொடுத்திருக்காங்க. It is property. Okay, so kindly read this definition very well. Okay, let's go into the detail of the establishment of the tribunal. So chapter 2 talks about establishment of the tribunal. So section 3, it speaks about establishment of tribunal. Section 4 speaks about the composition. Composition is very, very important. இங்க யாரெல்லாம் இருக்காங்க இல்ல members அப்படின்ட்டு அடிக்கடி கேட்பாங்க. So we have a full-time chairperson and we have a members, judicial members and expert members. So judicial member, as you all know from the background of judiciary, and expert member, subject domain experts. Okay, so judicial member from 10 to maximum 20 and expert members from 10 to maximum 20. Okay, apart from these members, chairperson may invite, if it is necessary, if he feels so, he may invite any one or more person having a specialized knowledge. So specialized knowledge and experience இருக்கிற person வந்துட்டு he can invite in a particular case to assist the tribunal. Okay, so particular case kaga, if the chairperson feels necessary, he can invite a subject domain expert, okay, to assist the court in that particular case. Next, let's see qualification. So qualification ரெண்டா பிரிக்கலாம், like judicial members and expert member. For a judicial member, a person shall not be qualified for appointment as a chairperson or judicial member of a tribunal unless he is or has been a judge of a Supreme Court of India or Chief Justice of a High Court. So வந்து பாத்தீங்கன்னா ஒண்ணு வந்து he a chairperson or judicial member எப்போ வந்துட்டு he can become is qualified அப்படின்னா வந்துட்டு either he is or has been, ஓகேங்களா, so present sitting judge or retired judge of a Supreme Court of India or CJ of a High Court. ஓகேங்களா, இல்ல அப்படின்னு இன்னொரு aspect இருக்கு, provided that a person who is or has been judge of High Court shall also be qualified to be appointed as a judicial member. Okay, so apart from this, a person who has been or who is a judge of High Court, அவர் கூட இந்த judicial member இருக்கிறதுக்கு qualified அப்படின்னு சொல்லியிருக்காங்க. இது section 5 for judicial member. Next வந்து பாத்தீங்கன்னா expert member qualification கொஞ்சம் lengthy-ஆ இருக்கும். So expert member qualification பாத்தீங்கன்னா he has to hold a degree in Master of Science, either in Physical Science or in Life Science, with a doctorate or Master of Engineering or Master of Technology, and experience of 15 years in the relevant field, including 5 years practical experience in the field of environment and forest. That includes pollution control, hazardous substance management, environment impact assessment, climate change, etc. in a reputed national level institution. So என்ன சொல்றாங்க அப்படின்னா expert member வந்துட்டு he should hold a Master of Science degree, either in physical or life science, either with a doctorate or Master of Engineering or Master of Technology degree. And you should have experience of 15 years in the relevant field, including 5 years of practical experience in the environment and forest matter in a reputed national level institution. சரிங்களா? இன்னொன்னு வந்து subclass B என்ன சொல்றாங்க அப்படின்னா has administrative experience of 15 years, including 5 years in dealing with the matters, environmental matters in central or state government or in any national or state level institution. So ஒன்னு வந்து பாத்தீங்கன்னா மேல வந்து இந்த following degrees இருக்கணும் plus years of experience. இன்னொன்னு என்னன்னா administrative experience of 15 years, which including 5 years experience in dealing with environmental matters in central or state government in a reputed national or state level institution அப்படின்ட்டு expert member qualification பத்தி இதுல பேசியிருந்திருப்பாங்க. Okay, so section 6 என்ன சொல்றாங்க அப்படின்னா appointment of chairperson, judicial member and expert member. So chairperson, judicial member and expert member of the tribunal shall be appointed by the central government. So who shall appoint all these chairperson, judicial member, expert member and partha? It has been appointed by the central government. Okay, so the chairperson shall be appointed by the central government in consultation with the CJI. So how the chairperson has been appointed abdina? He is of course being appointed by the central government, but the central government should consult with the CJI of India. Next, the judicial and expert members of the tribunal shall be appointed on the recommendation of such select committee and in such manner as may be prescribed. So, chairperson யார் appoint பண்றா, judicial member, expert member யார் appoint பண்றாங்கன்னு பாத்தீங்கன்னா, it's our central government. But chairperson special appoint பண்ணும்போது, you need the consultation of the Chief Justice of India. And for the judicial member and expert member, they are being appointed by the recommendations of such select committee that has been prescribed. So, இதுதான் வந்து section 6. Next, we have section 7. Section 7 speaks of terms of office or term of office. So, generally, they can work till 5 years till from the date of their entry into the position. So 5 years வரைக்கும் they can work. இதுல வந்து பாத்தீங்கன்னா retirement ages-உம் இருக்கு. Suppose the person who is or has been a judge of a Supreme Court has been appointed as a chairperson or a judicial member of the tribunal, he shall not hold the office after he has attained the age of 67. So, judge of a Supreme Court வந்துட்டு either he has been appointed as a chairperson or a judicial member, he cannot hold the office after 67 years. Likewise, if a Chief Justice of a High Court appointed as a chairperson or judicial member of a tribunal, he shall not hold the office after 67 years. Likewise, Judge of a High Court has been appointed as a judicial member of the tribunal, he shall not hold the office after 67 years. But expert members shall hold the office only up to the age of 65. So, in the judicial members எல்லாமே பாத்தீங்க அப்படின்னா 67 years வரைக்கும் they can hold office, but for expert member, they can hold office only up to the age of 65. Okay. So, next, we have relief, compensation and restitution. So, that is given under section 15. So, what are the relief available for the victims of pollution and other environmental damages arising out of this particular enactment given under Schedule 1. So in Schedule 1, they will be given a list of environmental legislations like Water Act, Air Act, and other acts. So we will be seeing in the later part of the slide. So அதில் வந்துட்டு யாருக்காவது வந்து பாதிப்பு ஏற்பட்டுச்சு அப்படின்னா they can claim relief, compensation and restitution. So first they will get compensation if it falls under Schedule 1. Next, restitution of the property damaged. Next, the restitution of environment for such area or areas. So these relief, compensation and restitutions are addition to the relief provided under Public Liability Insurance Act 1999. So Public Liability Insurance Act already you will be getting a compensation, and these compensation are addition to the Public Liability Insurance Act 1999. Okay. So next we have section 17, which speaks about liability to pay relief or compensation in certain cases. So in previous slide, we have seen about like compensation, relief and restitution. But if there's any death or injury or damage to the property or the environment, so what will happen? Then we can get the remedy under Schedule 2. So the tribunal will fix the compensation based on the principle called no fault liability. Okay. So this is Section 17. Section 17, they will give relief or compensation in cases like death, injury, or damage to any property and environment under any enactment under Schedule 1. So the person who is responsible for such incident, he has to pay compensation under Schedule 2. The tribunal will fix a compensation and relief based on the principle of no fault liability. Okay. So next we have procedures and powers of the tribunal. So the procedure and power of the tribunal, it has been treated like a civil code under CPC, but guided by principles of natural justice. Okay. So the powers are vested in a civil code under CPC and guided by the principles of natural justice. So natural justice இங்க இருக்குது. என்னதான் நம்ம CPC பிரகாரம் பண்ணாலும் natural justiceல இருக்கு இல்லையா? Audi, altum, partum, that is listen to both the side, and no one can be judge of his own cause. So அதெல்லாம் அந்த மாதிரி பிரின்சிபல்ஸ் எல்லாமே இதுல ஃபாலோ பண்ணுவாங்க. So இதுல இருக்கிற என்னென்ன பவர்ஸ் இருக்குன்னு பார்ப்போம். Summoning and enforcing the attendance of any person and examining him on oath. So first நம்ம சம்மன் பண்ணி அவனை அப்பியர் பண்ண வைக்கிறதுக்கு எல்லா பவர்ஸும் இருக்கு, and we will examine him on oath. Next is requiring the discovery and production of document. So we can discover and produce document, and the power இருக்கு. Next, receiving evidence on affidavits. So they can get evidence based on the affidavits. Next is requestioning any public record or document or copy of such record or public document. So we can question any public record and document. Next, issuing commissions for examination of witnesses or documents. So ஒரு கமிஷன்ஸ் வந்துட்டு நம்ம இஷ்யூ பண்ணி அதை பேஸ் பண்ணி நம்ம விட்னஸை வந்து எக்ஸாமின் பண்ணலாம், இல்லை டாக்குமெண்ட்ஸை எக்ஸாமின் பண்ணலாம். நெக்ஸ்ட் வந்துட்டு ரெவியூவிங் இட்ஸ் ஓன் டெசிஷன். அவங்க ஓன் டெசிஷன் இருந்தா கூட அதை ரெவியூ அவங்க பண்றதுக்கு பவர்ஸ் இருக்கு. டிஸ்மிஸிங் அண்ட் அப்ளிகேஷன் ஃபார் டிஃபால்ட் ஆர் டிசைடிங் இட் எக்ஸ் பார்ட்டே. ஸோ டிஃபால்ட் ஆயிருக்காங்க இல்லை எக்ஸ் பார்ட்டே ஆயிட்டாங்கன்னா அது அப்ளிகேஷனை டிஸ்மிஸ் பண்றதுக்கு உங்களுக்கு எல்லா பவர்ஸும் இருக்கு. Setting aside any order of dismissal of an application for default or any order passed by it ex parte. Okay. So next, pass an interim order, which includes granting an injunction or stay. So உங்களுக்கே தெரியும் interim order இடைக்கால ஆர்டர் கொடுக்குறாங்க. ஸோ இது வந்து எய்தர் வந்து பாத்தீங்கன்னா இன்ஜங்ஷன் கொடுப்பாங்க இல்லைன்னா ஸ்டே கொடுப்பாங்க. சரிங்களா? பட் திஸ் இஸ் ப்ரொவைடட் ஆஃப்டர் கிவிங் sufficient opportunity for both the parties to be heard. Okay. Next, pass any order requiring any person to cease and desist. So pass an order which requires any persons to cease and desist. Next, any other matter which may be prescribed. So once again, let's see the powers given to the tribunal: summoning and enforcing attendance of any person, discovery and production of document, evidence on affidavits, requisitioning any public record, issuing summons, reviewing its decision, dismissing an application for default, setting aside any order of dismissal, pass an interim order, pass an order requiring any person to cease and desist from committing or causing any violation, any other matter which may be prescribed. So இந்த பவர்ஸ் எல்லாம் வந்துட்டு இருக்கு. சரிங்களா? Next, we have tribunal. So tribunal to apply certain principles, this they might ask in examination. So this is very important. என்ன அப்படின்னா வந்துட்டு பாத்தீங்கன்னா, the tribunal shall, while passing any order or decision or award, apply the principle of sustainable development. So or then the precautionary principle and polluter pays principle. So tribunal ஒரு ஆர்டரோ ஒரு டெசிஷனோ கொடுக்குறாங்க அப்படின்னா இந்த ஃபாலோயிங் பிரின்சிபல்ஸ்லாம் அவங்க அப்ளை பண்ணுவாங்க. என்னென்ன பிரின்சிபல்ஸ் அப்படின்னா, பிரின்சிபல்ஸ் ஆஃப் சஸ்டைனபிள் டெவலப்மெண்ட், precautionary principle and polluter pays principle. So principle of sustainable development உங்களுக்கு தெரியும் இல்லையா? It is to meet the development of the present generation without compromising the future. Okay, so present generation oda needs a meet பண்றது without compromising the future generation. So you're using it sustainably. You're so accountable. நீங்க accountable நீங்க cautious judicious யூஸ் பண்றது தான் sustainable development. So precautionary principle அப்படின்னா வந்துட்டு நீங்க ஒரு ஒரு பர்டிகுலர் பொல்யூஷன் ஒரு பர்டிகுலர் டேமேஜ்னால சீரியஸ் irreversible டேமேஜ் நடக்கிறதுக்கு முன்னாடி precaution எடுக்கிறது தான் precautionary principle. And polluter pays principle is that is to pay if you are polluted and if there's any serious damages, the person who's responsible, he has to pay. That is called polluter pays principle. So the மூணு principle தான் வந்துட்டு the tribunal பேசி இந்த tribunal வந்துட்டு apply பண்ணுவாங்க while deciding the cases. It's given under section 20. Next வந்துட்டு section 22, appeals to Supreme Court. So in the order ஏதாவது dissatisfaction இருந்துச்சுன்னா you can proceed to Supreme Court within 90 days from the date of communication of this award. Okay, so this is the schedule. As I said, we have 3 schedules. The first schedule வந்து பாத்தீங்கன்னா they contain water pollution control and pollution act, prevention of control and pollution act, water prevention and control of pollution cess act, forest conservation act 1980, air prevention and control of pollution act, environmental protection act, public liability insurance act, biological diversity act. So indelaame schedule 1 la mention pannirukanga. So in the particular act la vanditu if there's any damages or any substantial question, or if you want to claim any relief, அதுக்கு எல்லாமே நீங்க வந்து ட்ரைபுனல்ல கேஸ் ஃபைல் பண்ணலாம். சரிங்களா? So next on schedule 2 and schedule 3. Schedule 2, it talks about heads under which compensation or relief for damages may be claimed. So எதுக்கெல்லாம் வந்துட்டு we can claim compensation and relief கேட்கலாம் அப்படின்னு சொல்லியிருக்காங்க. Like death, injury, disability or loss of work. இதெல்லாமே schedule 2 ல வரும். Very very important. And schedule 3, it speaks about amendment to certain enactments. Okay, so schedule 3 speaks about amendment to certain enactments. So this is all about important provisions under NGT. Kindly give a reading to it. This is very very important. Time and again we can find questions from NGT. In next like coming up are the important the previous year questions asked in our examination regarding NGT. Try to answer the question. Okay. Okay. So which of the following schedules of the National Green Tribunal provide for the heads of compensation? So எந்த NGT schedule la vanditu they provide for heads of compensation. That is schedule 4, schedule 2, schedule 3 and schedule 4. So which of the following schedules of the National Green Tribunal provides for the heads of compensation? Schedule 4, schedule 2, schedule 3 and schedule 1. So இதுக்கு என்ன ஆன்சர் இருக்குன்னு நினைக்கிறீங்க? So let me go to the answer. It's schedule 2. இப்பதான் நம்ம பார்த்தோம். So வந்துட்டு heads of compensation in case of any death, injury, loss of job அந்த மாதிரிலாம் இருந்துச்சுன்னா tribunal will fix the compensation. It is given under schedule 2. This is a previous year question. So whatsoever questions we're going to discuss, it's all belongs to previous year question. So kindly give a focus. So இப்படிதான் வந்துட்டு நம்ம the active படிக்கணும். So do not forget the schedule 2. Okay? Yeah. Yes. Correct answer. Schedule 2. So the next question is, the National Green Tribunal Act 2010 came into force on. So the National Green Tribunal Act 2010 எப்ப வந்துட்டு it came into force? இதுக்கு வந்து பாத்தீங்கன்னா 10 May 2010, 18 August 2010, 10 December 2010, 18 October 2010. So I started this with the beginning of our discussion. So இதுதான் நான் ஃபர்ஸ்டே சொல்லியிருப்பேன் beginning of the discussionல. எந்த டேட் it came into force on அப்படின்னு சொல்லிட்டு. So yeah, think an answer. Okay. Okay. So the answer is 18th October 2010. சரிங்களா? So இதுதான் நம்மளோட பேரக்ட்லேயே கொடுத்துருக்காங்க 18th October 2010. And presidential assent எப்போ கிடைச்சது அப்படின்னா 2nd June 2010. Okay, president assent கிடைச்சது 2nd June 2010 and it came into force on 18th October 2010. Okay. So next, the NGT Act 2010 contains how many schedules? So how many schedules we have in our NGT Act? 1, 2, 3 and 4. So எவ்வளோ schedules இருந்திருக்கு நம்மளோட NGT Actல? 1, 2, 3 and 4. So what's the right answer? So the answer is 3. We have 3 schedules in NGT Act. Next. Okay. So this is stated this in the beginning itself, that we have to study the preamble by heart, because they have a question with regards to the preamble of NGT. So preamble of NGT Act 2010 does not mention which of the following conventions, that is the Johannesburg Conference, Rio Conference, Article 21, then the Stockholm Conference. So எதை பத்தி மென்ஷன் பண்ணல, ஜோஹான்ஸ்பர்க் கான்ஃபரன்ஸ் மென்ஷன் பண்ணலையா, ரியோ கான்ஃபரன்ஸ் மென்ஷன் பண்ணலையா, ஆர்டிகல் 21 மென்ஷன் பண்ணலையா, ஸ்டாக்ஹோம் கான்ஃபரன்ஸ் மென்ஷன் பண்ணலையா. பிரியாம்பிள் என்ன சொல்லியிருக்கேன், எது மென்ஷன் பண்ணலன்னு சொல்லியிருக்கேன் நானு. Very good, very good. So Johannesburg Conference, because the preamble speaks about Article 21, Rio, Stockholm. Okay. So நம்ம வந்துட்டு preamble படிக்கலன்னா most of the people would have gone for answer C, that is Article 21, because இது எல்லாமே international conferences இருக்கு. கண்டிப்பா they wouldn't have spoken about 21 சொல்லிட்டு most of them would have gone for Article 21. So but the answer is Johannesburg conferences, which they have not mentioned in the preamble. Okay. So these are the important sections in NGT. So kindly give a reading. So that's it. That's it for today. Hope you enjoyed the video, and all the very best for your examination. Thank you so much. Thank you so much for watching.